Hi, everybody. We're going to give folks just a few minutes. I see folks are hopping on, so we will get started in about 30 seconds or so. Okay, we're going to go ahead and get started. I want to welcome everybody today to our webinar, M&S Predicts 2023 Privacy, TCPA, and Regulators Priorities. This is one of our favorite sessions of the year when we pull out that crystal ball and we have our partners give us their best predictions for the coming year. I'm Lauren Bernard. I'm the marketing director here at McMurray & Shuster, and I'm going to go over a couple of housekeeping things. And then we'll pass it on to our fearless attorneys here. First of all, I want to let everybody know that the webinar is being recorded. It will be available on our website likely next week. So it will be available there if you want to review it again or share with your colleagues. Secondly, we did receive quite a few questions at the time of registration. So we've got those noted, but I know that questions can pop up during the course of the presentation today. So if you have a question, please type it into the Q&A box that's on your screen. I'll be capturing those in the background and we'll send those to our attorneys at the end. We'll get as many as we can in during the session today. So with that, I actually want to introduce our attorneys, our founding partners of the firm, Helen McMurray and Michele Shuster. Helen has been a leader in the consumer protection arena for decades. She consults with and represents businesses regulated by federal and state consumer protection and privacy laws. And she regularly works with in-house counsel, executive management, and marketing and sales personnel. She is a former chief of the Ohio Attorney General's Consumer Protection Section, and she uses her experience and insights to focus on the defense of federal, state, and multi-state consumer protection investigations and enforcement actions. Michele is a former chief of the Ohio Attorney General's Consumer Protection Section as well, and she brings more than 2 decades of experience in consumer protection. Michele advises businesses on a wide range of privacy, advertising, and other consumer protection issues. And she has a particular depth of experience with the teleservices industry. She regularly represents clients in matters before federal and state regulatory agencies. She issues legal opinions on companies' outbound dialing solutions, conducts telemarketing compliance audits, and also provides defense in government enforcement actions. Michele also serves as general counsel to the Professional Associations for Customer Engagement, also known as PACE, where she also oversees its self-regulatory organization. And one last thing before I kick it off, we would not be a law firm if I did not give a disclaimer for what you are about to hear. The materials in this presentation are provided for informational purposes only. They don't constitute legal advice. Transmission of the information is not intended to create or constitute an attorney-client relationship. We know that every situation is different, so you shouldn't act or rely on any information that you learn today without first seeking the advice of an attorney, hopefully us. So with that, I am going to turn this over to Helen McMurray and Michele Shuster. And Michele, I think we're going to start off with you. There's a lot going on with TCPA and texting. So can you talk a little bit and share what will the new regulations for text messaging look like?
Lauren and Helen, I'm sure this is going to shock you, but I'm going off script here with 2 predictions that I didn't have until my phone rang right before we started the presentation, and I didn't turn the timer off, and it showed up as a spam likely, and it was actually a call from a medical facility where my mother is that they were calling about. So I'm going to be concerned about that. But more importantly, I think that, we're going to see a lot more of the blocking and labeling of telephone calls in a way that is not accurate and for calls that are completely legal. So I've changed my number one prediction to be that in that timely call that I received. Also, I am going to predict, Helen, that Ohio State wins the national championship in January, because I think they are very upset about losing to that team up north, and they're going to be on fire when it comes to playing Georgia and then Michigan.
We have one partner who will wholeheartedly disagree with you and a bunch of clients. Other than that, I agree.
I would really like to be able to celebrate while he's in the office, can I tell you? So anyway, so back to the topics that we're going to be talking about here today. So, the application of the TCPA to texting is such an interesting topic in and of itself. And we predict that it will become even more interesting in 2023 as plaintiffs' attorneys try to find creative ways to engineer cases against companies. After the Facebook case, which it very much narrowed the definition of an automatic telephone dialing system, and that triggering the TCPA, plaintiffs have been very creative in finding other ways to bring lawsuits. And texting is one of those issues. So in the beginning of 2022, there was an interesting case that was brought. It was called Glassdoor, and it's interesting because it alleged that a text message is a pre-recorded message because it's something that they're typing ahead of time and sending in a text message, which, just with common sense sounds absolutely ludicrous, but it is something that plaintiffs are starting to argue. And so, why would that be problematic? That would be problematic because with text messages after Facebook, we've assumed that generally ATDSs are not being used. But if the text message is a pre-recorded message, you're going to need prior express written consent before you send that message, or it'll be a violation of the TCPA. So that would be problematic, and it is something that we think we're going to see an uptick in 2023. Also, if you just look at the other TCPA requirements for placing telephone calls and the types of things that you would have to do, like provide disclosures for the name of the person calling, the company they're calling on behalf of, and for the TCPA, a telephone number or a business address at the end. That's very difficult when you're talking about, SMSs that are required to be a certain length of words, or for having succinct text messages. And also, if you're required to make a name disclosure for the agent placing the telephone call / text message, who are you going to put in there? It's not generally a human being that's hands typing out each one of those text messages. So it makes it very complicated and problematic. So this is one of those areas you should probably take a look at going into 2023. How is your company handling its text messaging campaigns? Do you have a defendable position against the TCPA for the texts that you are placing? Obviously, it would be extremely difficult if case law did turn to say that a text message is a pre-recorded message, because I'm assuming that most of you out there are not getting prior express written consent because it's not required right now, generally for text messages. But something to stay in tune with. Also, whenever I'm talking about text messages, I just think it's a good idea to remind folks about the CTIA, which is the Cellular Technology Industry Association, just to remind them about the best practices for sending text messages. I think it's a good idea to try to follow those. And also, just because we're talking about the CTIA, they have issued a best practices document for branded calling ID. So probably worthwhile to take a look at the CTIA website as you're heading into 2023. So Helen, I've lost the questions for your next one. Here we go. So CFPB, always an interesting area. And since you had the first fully litigated case against the CFPB, I think this is a good topic for you to talk about what we can expect to see with them in 2023. I think Helen has lost her mic or maybe her headset. Either that or she's responding to the emergency call I just got. So while we're waiting for Helen, I'm going to go ahead and go on with my next prediction. And it kind of follows along nicely with what we started talking about with TCPA and text messages, because the other interesting thing that we're seeing in the TCPA world is that there was a case that was decided a couple of months ago that we got involved with for PACE and filed an amicus brief. The case is called Shanette, or the plaintiff involved was Shanette. And what was interesting about it is that it had to do with B2B telephone calls. And the allegation in the complaint was that the telephone numbers that were clearly business numbers or arguably business numbers that were on the National Do Not Call Registry could not be called unless you had consent or scrubbed against the Do Not Call list. All of you out there that are doing B2B calls, you know that B2B calls were purposely exempt from the do not call requirements in both the TCPA, Telephone Consumer Protection Act, and the TSR, the Telemarketing Sales Rule. So this case is problematic because now we're left with the question, if you're making B2B calls, are you required to scrub against the DNC list? I think the one thing that is helpful in that case as we're going into 2023 is that it made it a question of fact as to whether a telephone number was actually a business number rather than a telephone number that was only used as a telephone number that for a consumer, not for a business. The reason that's important is because it becomes a question of fact. So then for any telephone number that is alleging that it was a consumer number and not a business number, you would have to make an individual inquiry, which would have a tendency to defeat any type of class certification, which is always the problematic issue when it comes to the TCPA. But so I point that out as we're going into 2023 to those of you that are making B2B calls. Make sure you're pretty confident that your lists are to business telephone numbers. I would also make sure that your purpose for the telephone call is for business purposes. If you're calling, relying on a B2B exemption, but it's actually a consumer product or service that you're trying to sell, that's going to lean more towards the fact that it was a consumer telephone number. So things to think about in 2023 as we're sure to see this issue come up. I would also just point out in this issue is that there is a petition that's pending with the FCC right now. It was filed by Todd Bank, a serial litigant out of New Jersey that uses he's an attorney, and he used his law firm telephone number as by putting it on the do not call list. And so he wants to be able to put that number on the do not call list and have no one call that telephone number that could be used for business purposes. So I don't know that we're going to have any movement on that by the FCC, but if we start to see a lot of cases, then potentially maybe that's another prediction for 2023. All right, Helen, before you had a crisis there, which I can't wait to hear about later, what's going on with the CFPB?
Well, we actually have a question that maybe you should answer before I move on. And I apologize for my Zoom crashing in one room, but I was able to recover quickly here. And we've got somebody asking about who has opt-in permission for, and they're talking about no-ring voicemails. The example is if you booked a client on a vacation presentation, they signed up for it at a special event, so that there's a relationship there. Are you able to drop a confirmation voicemail on their phone is the question.
So, the issue with the ringless voicemail, and it's something that we've pointed out for a very long time, is that if you're using a pre-recorded message for the ringless voicemail, which is how those systems work, then you are talking about needing the type of consent required for pre-recorded messages. And under the TCPA, that's prior express written consent. And so I'm not sure of the circumstances for obtaining that lead or having had the contact with the prior, customer. If you just were relying on an existing business relationship to not have to scrub against the do not call list, then that's not going to be enough for prior express written consent. That's something that actually has to be that language that the consumer signs, which can be an electronic signature that discloses that it can be a pre-recorded message and a marketing message, and that consent's not required for purchase. So you need all of those types of things if it's a pre-recorded message, which is what ringless voicemails have been found to be.
Thanks, Michelle. Appreciate that. So let's talk about the CFPB. I will admit that we did not predict last year that the CFPB's very survival was going to be questioned. But I am going to go out on a limb and predict that their survival as we know it next year is likely to change dramatically. And let me kind of circle back and tell you what has happened for those that don't know, and what the impact is now, and how far down the road there may be a greater impact. So what happened was in October, the Fifth Circuit heard an appeal from a company called the CFSA. It's a payday lender. And they said that the payday lending rules that the Bureau had adopted were unconstitutional for a variety of reasons. And one of those reasons, which was the funding for the CFPB, was not constitutional. And the Fifth Circuit agreed with that argument and said that the funding mechanism for the CFPB was unconstitutional on two different grounds, because it violated the separation of powers, and also because it violated the appropriations clause. And what had happened was that when the CFPB Act was enacted, they had a unique funding mechanism because they didn't want the CFPB to be able to be changed readily by legislation, because they wanted politics to be taken out of it as much as possible. And so all of the funding for the CFPB, to the tune of almost $2 billion a year, comes out of really monies that were set aside at the Federal Reserve. So they get a percentage of that money every year. And there's nothing that Congress has to do. There's nothing that the president has to do. It is automatic, and there is no oversight. And the Fifth Circuit held that, Congress holds the purse strings for a reason, and it's to balance those rights of both parties. And so therefore, it had to set aside the agency action, which is really the most important part of the decision. In that case, the agency action was the payday rules. And so in the Fifth Circuit, the payday rules are no longer valid and enforceable. So what's the impact of the case, and what does it possibly mean to the folks that are on this presentation? Well, first off, the Bureau immediately appealed it to the United States Supreme Court. So we are likely to have, and I'll talk a little bit about the timing in a second, something done quickly. But if in terms of what's actually happening in court cases pending today, and we're representing clients in those cases now, so we can tell you specifically what's going on. Within the Fifth Circuit, which is basically the state of Texas, all of the CFPB's cases are being stayed. That means that they're in hold, and they're going to sit and wait until the U.S. Supreme Court issues its ruling, and the Bureau agrees with that. Everywhere else in the country, and that's about somewhere between 30 and 40 cases, people like my law firm, we're moving to stay these cases as well, and because we want since the U.S. Supreme Court may be hearing this soon, the cases that we have pending are directly impacted. As of today, many companies have filed for this motion to stay, including all of our clients, but none of the courts have ruled on it yet. So we're kind of in a wait and see. We really expect to see courts to start to issue rulings on that. And quite frankly, we expect them to come down on both sides. I think some courts will stay it and some courts will not. And they'll just wait to see what happens next year. There's actually a really interesting angle in the Ninth Circuit, which those of you that follow these kind of cases know is frequently a very liberal court, and some of the most difficult decisions for companies to comply with have come out of the Ninth Circuit. However, the positioning now, and we know about this because one of our cases that is actually involved in it, leans towards the Ninth Circuit actually supporting the Fifth Circuit's decision. And the reason is because it's the makeup of the panel of a case that's pending in San Francisco. Our firm actually had the opportunity to try the first case against the CFPB. I think Michelle may have mentioned that as I was phasing out there on my Zoom. And that case is actually pending before the Ninth Circuit right now. And the unconstitutionality of the funding of the CFPB is one of the issues there. This case has been fully briefed. It is ready for decision. It's been pending there for years. But what makes it so interesting is that the three judges on that panel for, it's called the Nationwide Biweekly, are the three dissenting opinions in the CLL law case, which found that the single director was unconstitutional, but that it was severable from the rest of the act. And so the CLL law case was able to proceed. And if you read the dissent of those three panel members, who are the only three panel members on the Nationwide case, it seems very likely that their distaste of the CFPB and all of its power in one particular area, especially in terms of separation of powers, looks very, very hopeful that panel would actually find, similarly to the Fifth Circuit, and then basically every CFPB case in the Ninth Circuit, which is quite a few, would then likely either be dismissed or automatically put on hold or on the stay. So when might that all happen? So the CFPB actually had the opportunity to appeal to the Fifth Circuit en banc, which is every single judge. And they skipped that opportunity because they wanted this to move very quickly. And so in January, the U.S. Supreme Court will actually be deciding which cases it chooses to hear for the rest of the year. So we should know in January whether or not they're going to pick this appeal or not of the Fifth Circuit case. I think everything that I have read indicates it's very likely, since it's a decision of manifest importance. And then the way the court's calendar works is then if the case is selected, arguments would have to be heard by April. And then typically a decision by the court would come down in June. For those of us that are litigators, this is lightning speed, especially in the federal court system. So that is the timing of all of this. Now, what agency actions are we talking about? What else might be impacted by the CFPB? I think the obvious answer is the lawsuits, because that's already happened. But what is an agency action? Is it an investigation? Maybe. Is it settlements? Maybe. So we're going to kind of have to start looking and fleshing that out if that becomes an issue. I think one thing that it is pretty likely that will continue are the examinations of banks and companies, because those are not particular actions. Now, if they wanted to take an action from an exam result, that would probably fall in the bucket. But right now, we anticipate that and all the education efforts and all the outreach that the CFPB does, keeping its website up, all of that will probably remain unaffected forever while we wait to see what happens on the enforcement actions. But as we all know, the CFPB is not one to take things lightly, and they will continue on as much as they can, wherever they can. So I think that while they wait for this to go to the Supreme Court, that they are going to continue forward. I do think, though, and that this is the basis for my crystal ball telling me that the Bureau is going to be in trouble, is we've got a court that's packed by Trump. We saw what it did in the abortion issue. I would have a really hard time thinking that this court would not concur with the Fifth Circuit. I do think that they'll look at it very specifically on the constitutional issues, but what was laid out in the Fifth Circuit was really very overwhelming. And you put that with a very right-wing court, and I think that it looks ominous for the CFPB. But where they will proceed, I think what they're going to move, what decisions they're going to make moving forward, I think they're going to back up on payday lending. I think they realize that those rules are clearly a question, and I don't think we're going to see much action there. They do seem to be ramping up, and they've provided advice in some of their findings from examinations on student loans. And they are, I think, also going to react to the confusion over student loan forgiveness. One day it's on, one day it's off. And there are always folks who try to take advantage of that or use it as a selling tool. And so when it comes to misrepresentations about eligibility for forgiveness and what can or can't be done for consumers, that I see as something that's going to continue to be on the top and rise to the top. We've got the findings that colleges and universities or their representatives are saying that you can't get a transcript as a student because you are behind in your loan. Those types of misrepresentations and things that are prohibited are going to be problematic. And then the last two are kind of more on the technology side. The Bureau found significant problems with missing information on student records. And as a result, wrong information was being given to consumers. Students were being sent to the wrong place. They were told the wrong information. And that was very problematic. And then from the call center area, Again, I know from my own kids who have student loans and would love to see them forgiven, they're calling and they're asking questions about what's going on. And the call centers are just unable to handle the increased volume. And so I guess the conclusion there is that when the president decides to do something, you got to start ramping up your call volume because you're going to get dinged for it in an exam if you are not keeping up with it. So that's a particular area to be concerned about. The other area that the Bureau found significant problems with is in the collection of medical debt. And under the No Surprises Act, they're finding multiple violations of the Fair Credit Reporting Act, which the attempt here is for that people going to get health care that they know and they're informed about what the costs are before they actually have to incur those costs. And for insured persons, they are finding that companies and entities are violating what's called the balance billing prohibition. And a balance bill is when insurance will cover part of your cost, but not all of it. And then the remaining cost is passed along to the patient. And under the No Surprises Act, there's actually prohibitions from doing that on a lot of areas, significantly in the emergency room, anesthesia bills, and in x-ray bills. So that's an area that has been problematic. And then for self-pay patients, providers are required to be giving, or their representatives, the good faith estimate of these, either it's a consumer product that's being purchased or whether it's being a surgical procedure or that type of thing. They are required to give a good faith estimate for self-pay patients, and they're not seeing that that's happening much at all either. So that's kind of a quickie overview of the Bureau. We may not see it having much in the way of clause next year, and certainly with the dysfunction of Congress, if that's the way it turns out, it's going to stay that way for a while. Michele?
Lots going on at the CFPB. Definitely something we'll pay attention to in 2023. So next topic, and Helen, I'll appreciate you weighing in on this too, because I know you've had involvement in some state cases that are going on right now. But we predict in 2023 that we will have some very interesting decisions in the courts regarding what constitutes valid consent to place a telephone call or a pre-recorded message or a text for purposes of the TCPA. And I wouldn't say just the TCPA. I think most of the folks on this call are most interested in that. But I had a fireside chat with Lois Greisman, who's the director of the Consumer Protection Bureau at the FTC during our PACE ACX in October. And one of the things that she wanted to make a point about is what it takes to actually get this prior express written consent or prior consent to place pre-recorded messages, which she would call a robocall, to consumers. So what does that lead form need to look like? Well, what she stressed first was that it can't be, and this was her words, a consent farm. Meaning that you can't have a lead generation form that then links to, and I think she said thousands of marketing partners that are also getting consent. And she stressed the fact that when consumers are filling out these forms, that they aren't clearly and conspicuously put on notice as to what's going to happen as a result of submitting their information on those lead forms. And she ended by saying that it is her belief, and she is just a staff, albeit a very powerful staff person at the FTC. It's her belief that you can only get consent for one company at a time. So, in that conversation, I pushed back about a prior staff opinion that talked about getting consent in a lead form that was limited to, a specific industry. In the case of that staff opinion letter, it was the mortgage industry, and that the consumers would be put on notice about how many telephone calls they would be receiving as a result of submitting that lead. And so giving her some examples, she said, well, that's certainly something that the FTC would not pursue if they went through all of that and consumers weren't getting inundated with telephone calls. Which that's good to know with the TSR. There's not really a private right of action in the TSR because it requires actual damages, which is very difficult to prove with a telephone call. But it's pretty obvious that the FTC and the FCC are in close communications with each other when it comes to these types of issues. Shortly after that event in October that that we had our fireside chat, the FCC on November 10th put out a new agency action, DA 22-1182, for those of you that would want to look that up. And it involved a telecom provider that was by the name of Earth Access, URTH. And the FCC issued an action against them, alleging that they were making unlawful telephone calls and that they didn't have consent for those. But what's interesting about this agency action is that it specifically went on to say, and of course in a footnote, because that's where you put important information in these types of things in a footnote 21, if you're keeping track. It says the commission's rules provide that to be clear and conspicuous, meaning the disclosures you need for prior express written consent. So in order for them to be clear and conspicuous, the disclosure must inform consumers that they will receive future calls that deliver, and in this case, it was pre-recorded messages on behalf of a specific seller. So the FCC, in interpreting its rule, albeit in an informal way through this enforcement action, is also saying that needs to be a specific seller. So what does that mean for 2023? It means for 2023, we really need to go in and take a look at the language that we're using to obtain prior express written consent to make telephone calls, because I think this is an area where we are going to see a lot more action by plaintiffs' attorneys in the TCPA area. This is something they're really going to start pushing, and we need to be prepared to defend those actions. So you need to have what we call a defendable position. So if you haven't had your consent language, or if you're a voice service provider or a carrier, if your customers haven't had their consent language reviewed in a while, I think now is a really good time to do that at the end of the year or beginning of 2023 to make sure that you do have that defendable position in case, God forbid, the FTC or FCC come knocking on your door, or if you get a TCPA class action brought against you. I will just say the other interesting thing about this Earth action is that the FCC is using right now as its strongest weapon the fact that if the company does not comply with and fix the deficiencies that they pointed out in the enforcement notice, that they will instruct all downstream carriers to block all calls involving Earth or being initiated by Earth. So that's something that we're seeing as a common practice now with the FCC. Prior to starting probably a few years ago, it would just be a notice that would be issued. Now they're using a very powerful tool by saying we will block your ability to even initiate calls, be that a seller or a voice service provider or a carrier. And Helen, I know you've been dealing with a few cases on the state level with state AGs. What are they saying, and what do you think about for 2023?
Yeah, the state AGs, every single one that I've talked to has mirrored what you heard from Lois Greisman in terms of that there is a very narrow scope of what a written opt-in consent can look like. And I have put dozens and dozens of these consents before them, as well as the FTC, quite frankly. And some of these come from, large publicly held companies. Some of them are from smaller lead sellers and lead brokers. I haven't seen one yet that any of the state AGs have indicated was prior or met the standard of prior express written consent. And what they're looking at is not just the one seller, but they're looking at those pop-up little hyperlinks and the pop-ups, even if it pops up right then. I have one investigation by a state AG where the lead broker did come in to defend these leads on behalf of my client, who was the one actually making the calls. And quite frankly, they've been over backwards trying to come up with different ideas to make this work for different sellers. And very unexpectedly, the Attorney General just brought suit against the lead broker. So these continue to be very much under question. But I'll tell you, Michelle, there's just not a lot of litigation out there. What they're doing is they're pressuring companies, unfortunately, some like that we've represented years ago, because what happens is that if you are wrong about this, okay, you take the hundreds of millions of calls that you're making and multiply it times the penalty amount, and you're off the calculator. already. So these are almost bet the company types of litigation. So they are forced to settle. So that's something that I'm a little nervous on a prediction on that one. I think it's going to remain in limbo, to be really honest with you. One thing that you can do in addition to your suggestions, though, is I also haven't had a lead broker yet who has agreed to indemnify the company that was making the calls and who came under the investigation. And quite frankly, some of these agreements with the lead broker require it, some of them don't. But at a minimum, you should make sure that these agreements do have a really rock high or strong indemnification clause, so that you can go after them if you're the only target of the investigation, or you can do what we did, which was try to bring the lead broker into the investigation when you were unable to get the AG to agree to the validity of the claims. And I expect to see some more of that. Can we talk some more about some AG stuff? I think, Michelle, you're muted.
Just talking a little bit more about the lead gen stuff. Another prediction that I will make is that PACE will have its performance marketing SRO up and running, and it will become an excellent tool for companies to mitigate the risk and actually know what the law requires and how they can meet that. So stay tuned for the PACE performance marketing SRO.
Absolutely, and I think it's going to be really important, because one of the things that I absolutely predict state AGs are going to continue to do is to every state attorney general, Republican or Democratic, independent, all agrees that they hate robocalls and they want to put them out of existence. And that has not changed with the recent election. Back in November, we had 30 different state attorney general offices up for vote. And it was 15 Republicans and 15 Democrats. So everything has stayed exactly the same in terms of the party dynamics. I will say, though, it's kind of interesting if you look at the latest FTC do not call report. There are certain states that are just being pummeled by these robocalls, which they define as having pre-recorded messages. Primarily Ohio, who has, as Michelle and I both know, has been very, very active in the robocall investigations and lawsuits. As well as Delaware and Arizona. That report's available to the public and has lots of stuff for all the telecom geeks out there if you're interested in. Also, the state AGs, all are 51 of them, which include one of the territories, did just sign on to a letter to the FCC, strongly supporting the fact that VoIP providers be required to uphold the stir-shaken method, because they're finding that most of these robocalls are coming from VoIP providers, and so therefore they're looking to keep them under that stir-shaken as well. So there's lots of distractions, however, with state AGs. We have a tremendous amount of politicism that has really entered the arena, so much more so than when Michelle and I were consumer chiefs. I won't say how many years ago now, but a while. And as a result, they're focusing a lot on these political issues. An example is the multiple Republican AG lawsuits against different Biden administration rules, regulations, those types of things. For a while there, the COVID was a huge distraction, and that really seems to be going away. But I'm also seeing a return as COVID dies out, a return to kind of what I call the bread and butter consumer protection violations, which are things like ad substantiation and things like that. So it's kind of mellowed out from that perspective. What has also kicked up, though, into high gear is what we call our multi-state investigations. And that is when a number of states, almost always, frequently a nonpartisan group of states, Republicans and Democrats, will come together to go after a very large target. And back when I was consumer chief, that's when these kind of cases really began to take a high profile, when we brought cases that involved 48, 49 states, such as the tobacco lawsuit and the original Microsoft lawsuit. And really what we're seeing now, first of all, the last few years have been dominated by the opioid multi-states. And I think we've all started to see them settling. CBS just settled within the last week or so, as well as many other of the drug companies. And so that is getting them ticked up for what's going to come next year. For what my prediction is that we're going to continue to see an enlargement of these lawsuits against not only the tech companies like Amazon, Google, but also the Facebooks, the Instagram, and it's been significantly, of course, before in the privacy area, but I'm going to see it in the consumer protection area because I shop on all of these devices and platforms, and none of them are fully complying with the consumer protection laws of any of the states. And the excuse is that if we did, then it wouldn't be quick enough, and that's probably where a lot of people aren't complaining, or it wouldn't be as easy and that type of thing. But they're going to have to come to pay the piper on this one, and that's my prediction for next year, is that multi-states are going to really address the purchasing way the consumers are interacting with it. And they're going to start with kids because that's really a vulnerable population. They are so darn smart, and they can get out and get mom's and dad's credit card or whatever, or Apple Pay, and they'll be able to get out there and order things. And that's also going to be problematic for them. So basically the online marketplace by tech companies is my prediction for a big pump up in multi-state action for next year. Back to you, Michelle. We're going to be going to the FTC. And you're muted. I think you're muted again.
State, let's start now with the state Mini-TCPAs. And so, Florida really started the charge with that, with putting out a Mini-TCPA, meaning that it basically requires the same types of things as the TCPA, consent for calls, disclosures, those types of things. And so after the Facebook decision, which made it very clear that you have to use a random and a sequential number generator and then call those phone numbers that were randomly or sequentially generated in order for it to qualify as a call using an automatic telephone dialing system or as an ATDS. Well, a lot of states started looking at their telemarketing rules and laws to say, well, if the federal law is no longer going to have as much teeth in it, what can we do to put more teeth into ours? And Florida started that trend. And what they did was they looked at their definition of what kind of telephone system is going to trigger those elevated consent requirements. So consent to call a cell phone or consent to send a pre-recorded message. And they changed their language. Instead of using an automatic telephone dialing system that has to use a random or sequential number generator, to just using an automated system. And they don't really give a definition of what an automated system is. And so we know plaintiffs' attorneys love that type of thing where there isn't a clear definition on what triggers the law. And so there have been numerous lawsuits that have been filed in Florida, and we anticipate that trend will continue in Florida. And it will continue until we get some kind of clarity about what an automated system is. Is that just a system like a predictive dialer that automatically sequences when telephone numbers will be called, or that will automatically dial without the telemarketing sales rep having to actually dial or initiate that telephone call, or those automated systems? And if they are, then almost all dialing systems that contact centers and businesses are using are going to fit under that definition that also has a private right of action. So we anticipate in 2023 that we will see more states mending their state telemarketing laws to accomplish what Florida is trying to accomplish here, which is to recover from the Facebook decision and to put more restrictions on callers into their states. We had Washington that passed a law. It didn't really go as far as Florida did, so not too much of a concern there. Oklahoma also passed a law in 2022 that appeared to be very tough and would have been much like the Florida definition of the type of system that would trigger it. But in Oklahoma, there's an exemption that applies that basically mirrors all of the entities that would be required to register under the Telemarketing Registration Act in Oklahoma. So in other words, if you're a certain type of business and you don't meet certain exemptions, you have to register as a telemarketer in Oklahoma. There are not a lot of companies that are registered in Oklahoma. I'd be surprised if very many are, if any, on this call. And so if you are not required to register in Oklahoma, you also would not be required to change how you are calling into Oklahoma based on that new law that they passed last year. I'll tell you that there are a lot of bills pending on the state level. One of the more recent ones is the Michigan Mini-TCPA. That's something that we are looking at on behalf of PACE, and something that we are most likely going to become active in educating Michigan AG and legislators on. There are some very problematic provisions in the Michigan law, including not providing an exemption for existing business relationships under their basic DNC laws. Also, it is broad enough that any type of predictive dialer would be considered the type that would require that prior express written consent, among a large number of other provisions in Michigan. So we're concerned about that, and that's something that we'll be looking at. It is not surprising that Michigan is one that is really pushing the envelope, because they have been one of the states that is leading the anti-robocall task force that Helen mentioned earlier. So that is not much of a surprise. So make sure you're monitoring legislation in 2023 to see if any of these state laws pass. Obviously, we'll also notify you if that does happen. All right. Helen, am I turning it over to you?
Yes, you are. Yes, you are.
Excellent.
So we're going to talk about the FTC a little bit. One of the questions that we had before the presentation started was, are we going to see state AGs partnering with the FTC? And, Michelle, you've mentioned a couple of times about the FTC's limitation in the AMG case, and they're still reeling from that, but they are finding workarounds. And I definitely predict for next year that we're going to see more of those workarounds, including state AGs. I don't know that it's going to include large groups of them. At a recent state attorneys general meeting, there was quite a significant discussion around these multi-states and the breadth of them and the unfairness towards business. And you definitely saw a lot of the Republican AGs hearing that and having concerns. So what I am seeing is, like, New York and the FTC are like that. Okay. They've got a number of cases in a number of different areas, and there are plenty of other states like that, or groups of states. In fact, the Illinois Attorney General, he is now the co-chairperson of NAG, that's the National Association of Attorneys General, the NAG Consumer Protection Committee. That's been a very active state, and of course California always is as well. So we're going to definitely see that partnership continue to strengthen, and they are also not shy about filing suits, and it works very well for them for that, especially in New York with Letitia James. But what else will we see? The AMG limitation is on the ability to get civil penalties in cases. And so where there's a rule, there is an automatic right to civil penalties if it's proven according to the statute. And so the two areas that you're going to see, I think, the most action, we're already seeing some of it, is the telemarketing sales rule, of course, and then COPPA, which is Children's Online Privacy Protection. If you have any type of marketing that could possibly thought of to be of interest to those under the age of 13. It's been a kind of a quiet rule for a really long time. And then, wham, we had a case recently where a huge, almost $300 million civil penalty was awarded for COPPA violations against the maker of the Fortnite game. Largest penalty ever assessed against a company for a rule violation. So that's going to be, kids are considered vulnerable populations. And I think especially that in between, I guess the home tweens, that 13, 12, 11, 12, it seems to be getting younger and younger every year with kids that are actually out there online and that type of thing. So I definitely predict that we're going to see a lot more COPPA cases, and they're going to be ugly, quite frankly, because no one's been really minding that shop for a while. The other thing we've already started to see a little bit of, and I think we're going to see more of it, it's kind of sexy anyway, is these endorsement guidelines. And that's the influencers that are out there. Again, I think I'm seeing some compliance out there, but overall not. Basically anyone who's out there, a celebrity and an influencer who used to be just a regular teenager at a high school, and now she's got $1 million book of business because people like the way she puts on makeup. They've got to be out there disclosing, according to the rule, that they are being paid to review these products, and you're still just not seeing that out there. And I had to laugh because, I mean, rarely, Michelle, do we ever get the SEC to be involved in these kind of cases, but poor Kim Kardashian, she got smacked for $1 million by them because it was a publicly held company and she had failed to disclose that she was being paid for her comments and her time. So that's going to be an area. And I know even if you're talking about a car dealer who hires a local football player, it doesn't have to be big and glamorous like the Kardashians. All of those types of comments, you've got to be indicating to the person, depending upon these guidelines, that they are either receiving a free product or they're being paid if that's true. They're not really all that complicated. There's a great guideline on the FTC's website as well. So it's just a matter of knowing what that is and then making sure that your ads comply. And if you're hiring a marketing company to do this for you, I have not seen compliance with these marketing companies. I mean, it's been very poor. They are not aware of it. They don't care about it. And so you can't just blame the marketing company did it, not me. You've got to vet them to make sure that if you're going to be using influencers, that they know about these guidelines and that they're complying, or better yet, have an attorney who's knowledgeable vet the company for you. And I haven't found one yet that passed muster. So it's a significant problem out there. The other area that's new for the FTC, and I also envision will be big in enforcement actions next year. Right now, they're in the middle of adopting what's called an imposter rule. And I think generally what we're all thinking of is the grandparent scheme, which is an elderly grandparent who has multiple grandkids gets this phone call, and sadly, little Johnny is down in South America and he's in jail and he needs $1,000 to get out, and you got to wire it, and the grandparent gets so wrapped up in the drama that they forget they don't have a grandson named Johnny or the like. But really, it has a commercial application as well. I mean, I call the grandparent thing a criminal action. And where we're seeing it is in the charitable, the nonprofit front. Are the people calling you? Are they pretending to be policemen or retired firefighters? Are they really veterans? Are they not? And you don't have to be a veteran to collect for a veterans charity, but you just have to make sure that you're not making it seem like you are a veteran, most certainly not like a wounded veteran. But that's where we're seeing a lot of that, imposter type of thing come up. We're seeing it in the coin industry because a lot of these companies that just sell coins call themselves mints, or they refer to U.S. coins. And many, many times consumers are led to believe that they are buying it from either the U.S. government or a U.S. government approved company when that is not the case. And those would also fall under the imposter rule. And then other things like credit card companies where you get a call and you're not sure whether or not it really is your credit card company or not. So maybe someone trying to sell add-on products, those types of things. Even if it's a commercial for-profit business, you cannot pretend to be them or sound like them. I mean, we get people who say, I'm calling from the clerk's office, or my return address has got a symbol on it that looks a lot like the U.S. Mint or Department of Education. All of those types of things are going to fall under this new imposter rule. Probably the last category I'm seeing a lot of this in is in utilities, solar and those types of things where people are either pretending to be the utility in the area, like a Columbia Gas or a PSE&G, depending on where you live. And you can't be doing that either. If a consumer is led to believe that you are a true, public utilities company as protected by state and federal law, and you're not, that's going to be a violation of this rule. And if you remember, rules still have the ability for them to get civil penalties. So that's going to be problematic. One of the elements of the imposter rule is that it applies not only to those folks who are making these claims, but to others who have the means and instrumentalities, that's their word or phrase, to help them. And these would be people like credit card processors, other types of things like that. And they are parts of a cog in the system. And you've already seen this in telemarketing, whereas the scam can't go forward or the misrepresentations can't go forward without that important entity. And they are specifically permitted to bring enforcement action against these third parties for the imposter rule, again, with that ability to get civil penalties against them. They call them dominant intermediaries. And I know Michelle has seen a lot of that with regards to her work with the FCC. Other areas real quickly, a new health products compliance guide just came out from the FTC. And that is not just nutritional supplements, but it's also going to apply to food that makes health-related claims, over-the-counter drugs, medical devices, And this guideline hasn't been updated since 1998. And so my big crystal ball says the health claims are going to be all over the FTC next year. And no holds barred as to whether it's clothing that's going to protect you from the sun, or yogurt that's going to help you have lower cholesterol. So that's going to be my other thing for you to watch for in 2023. And then Michele, I think you got some privacy to talk to us about.
Yes, some privacy updates. I think we've all been following anybody who does direct-to-consumer sales and advertising or marketing or selling has been following the states that are passing their privacy laws. And, California got it started, still the most stringent of the state privacy laws. Their California Privacy Rights Act, or CPRA, is taking effect on January 1st, 2023, as is Virginia's Consumer Data Protection Act. So that's right around the corner. And we know that once these take effect, that the regulators are going to be anxious to start some enforcement actions so that they can make examples of companies. It's how they get their message out there, and also get other companies to start moving into compliance. Some folks are holding off on fully implementing the California privacy requirements because California has announced that they will not start any type of enforcement action until July 1st of 2023. And what's important to know about that is they say they won't start enforcement until July of 2023, but it could be for actions that occurred in or after January 1st. So I would tell people to start moving on that, even though the enforcement deadline isn't until July. Also, we have Colorado and Connecticut. Their privacy laws will take effect on July 1st, and Utah then on December 31st. So I can guarantee you that there will be enforcement actions by the regulators for these privacy laws. It's something that they have felt very passionate about as they've gotten those passed. We do also have the FTC that put out a notice of proposed rulemaking in the privacy area. They are getting a lot of pressure to pass a privacy rule in the absence of the federal Congress actually enacting a federal privacy law. And so the FTC put out their notice of proposed rulemaking. They have extended the deadline for submitting those comments a couple of times. But I do know that they are looking at really pushing hard if Congress does not. I would also say, though, that the federal bill that was introduced that would be a federal privacy law, the ADPPA, the American Data Privacy Protection Act, would give the FTC rulemaking authority. So I think no matter what, the FTC is just moving forward with that rule, thinking that one way or another, they are going to have the ability to pass rules that would be a federal privacy rule. And so I think we're going to see some movement on those types of things and state regulations in 2023. So this is another area like Mini-TCPA that you really need to make sure that you are monitoring legislation and are aware of when it passes. Make sure you're signed up for notifications, like our blog will notify you if any of those types of things happen.
Michele, I got a question for you. We have a question from the audience. Asking about, with the CCPA and the TCPA, should they be finding the most restrictive position, and then basically that should be your requirement? They're finding that clients are asking them, for example, to destroy all data when the relationship is over, and they're concerned because then what do they do when they get sued?
Yeah, no, that's a great question. So the good thing about the California law and the other state laws is there's an exception about destroying consumer information upon a deletion request from the consumer. There's an exception if you are required by law to keep that information, or also if you're required to keep that information so that you can consummate the sale or whatever the purpose of the communications were with the consumer. So if you're holding on to the information after a deletion request to comply with the TCPA or to consummate the sale, then you are going to be fine. But the thing we always caution clients about in that area is that exception is very narrow, and you can only use the information that you're not required to delete for those areas that meet the exception. So, if it's an issue with the TCPA, then you're going to want to make sure that you put them on your do not call list, and you don't call them beyond that, because it's basically should be treated as a revocation of consent. Also, if they're making that deletion request, and after you get done with the sale and you've used the information for what you were required to use it for or needed to use it for, you should not make any more sales pitches to them. So make sure that those kind of things are feathered into your privacy policies and procedures as you're implementing these regulations.
Michele, we're at 2:00, but just a quick question, because you talked about exemptions. It looks like the Oklahoma Mini-TCPA is full of exemptions. Does it really apply to anybody? And then that will be the end of our time.
Well, and it only applies to those people that are required to register in Oklahoma. Kind of a bizarre twist to the rule or to the law, but that's how it is. And like Lauren said at the beginning, if you have any questions that we haven't had a chance to answer, because, we tried to be thorough in the information we gave you up front, don't hesitate to reach out to us, and we're happy to work with you on those.
Well, that's it for
Great
today.
job, Helen.
Thank you very much.
Do this again next year.
Absolutely. But I like to sit in front of a crystal ball. Maybe we'll predict some good ones this year. So
there you go.
Thanks to everybody for tuning in. We really appreciate your support and continuing to follow us. Best wishes for really happy, warm holidays for everybody. And we'll look forward to seeing you again soon. Take care.